Welcome, everyone. My name is Korkor. I'm the founder and the CEO of the A.B. Korkor Foundation for Mental Health. This is another one of our podcast series that are aimed to help you address some of the issues that causes you stress and discomfort. Our topic today is on advanced directive and living well, advanced life planning. It's a topic that we all have to be concerned with and have to be prepared for. As a physician who've taken care of thousands of patients over the years, this has always become and became available, this has always been a very important aspect of the care for the patient. Well, I am so honored to have attorney Terry Campbell with us today to discuss this topic with us. Attorney Campbell is a member of the board of directors of the A.B. Korkor Foundation. We are so proud to have him on our team. He is also the managing shareholder of Moertl, Wilkins and Campbell, which is a law firm in the Milwaukee area that has been in business for over 7 years. Attorney Campbell himself has been in the practice of law for 40 years.
Yeah, thank you.
Welcome, and I look forward to hearing your presentation, and we'll have some questions and at the end and some dialogue. And I welcome you, and I thank you for taking the effort to join us.
Thanks, Adel.
On these podcasts.
Just gonna briefly, before I eliminate my picture, tell you that my practice has always focused in estate planning, elder law, and tax. And despite the education that we try to do with our clients, we find that these concepts are so easily misunderstood. So I'm going to start with basics. I'm going to add other comments that hopefully you will find beneficial. And if you have follow-up questions, hopefully we'll be able to address those as well. An advanced directive refers to usually a living will, a healthcare power, and sometimes a mental healthcare power of attorney. And I like to start with this slide because often 10 years maybe after we've met with a client and we've done a healthcare power of attorney, we'll get this panicked call because maybe they went to the doctor or maybe somebody had some sort of procedure and they're calling saying, oh my gosh, I don't have an advanced directive, so I need to come and see you. And so we remind them, no, you have a healthcare power of attorney. And that healthcare power of attorney is the advanced directive. If somebody suffers an incapacity and they don't have appropriate planning documents in place, a family member will typically have to go through a court-administered guardianship proceeding to become appointed guardian over that individual's person, and perhaps also as the guardian over the estate. When a person executes a thorough healthcare power of attorney, they're doing everything possible to avoid a guardianship over the person. In a similar fashion, if you have executed a thorough financial power of attorney, you're doing almost everything you can to avoid that guardianship over the estate. Now notice I'm saying everything possible. Does this guarantee you will not have a guardianship? No, it does not, unfortunately. There are certain mental health conditions or certain other conditions of aging that perhaps we become hostile and combative. And if a person is going to be placed in a facility for care, that facility will insist on what's called protective placement. And that is something that is only achieved through a guardianship process. Wisconsin provides both a healthcare power of attorney and what is often called a declaration to healthcare professionals or a living will. So the question that we are often asked is, do I need both documents? For most people, I don't believe you do. When we draft a healthcare power of attorney, probably 95%, maybe even more of the time, we incorporate all of the wishes regarding life-sustaining procedures and feeding tubes within the healthcare power of attorney. By doing it in this fashion, you will always have a healthcare agent who can be your advocate, who can indicate what care perhaps they believe you should have, what care you shouldn't have, perhaps what sort of care should be discontinued. You have an advocate by having the healthcare power of attorney. So some definitions, just so if I refer to this later, we're all on the same page. A healthcare agent. A healthcare agent does not have to live in this state. They can live anywhere. Now, obviously, there are advantages by having a healthcare agent close in proximity in case they have to respond to a medical crisis. It's a little bit easier to travel. But it's anyone that you choose to make as your appointed agent, and always appoint an alternate agent. Defects we see is where an alternate is not appointed and your primary agent dies or becomes incapacitated, then the principal becomes incapacitated. Now you have no agent, and once again, you're probably going to be making a trip into a court guardianship process. In Wisconsin, we define incapacity as the inability to receive and evaluate information effectively, or to communicate decisions to the extent that an individual lacks the capacity to manage his or her healthcare decisions. This is a statement that a doctor signs, and that is what activates your healthcare power of attorney if it is contingent upon incapacity. And I'm going to come back to that in a few minutes when we talk about how a healthcare power of attorney can be effective. Anybody age 18 and of sound mind can execute a healthcare power of attorney. That means if you have children and they're graduating from high school, and very often they are age 18, that child should have a healthcare power of attorney. If your child goes off to college and you get that call that none of us want to get, that there's been an accident, you will have limited ability to make any decisions regarding that child's healthcare because they are now an adult. They're no longer a minor child. We may not consider them an adult for many reasons at age 18, but by law, they are considered an adult. Now, let's talk about incapacity. Our statutes say that unless otherwise specified in the power of attorney document, the healthcare power of attorney only takes effect upon a finding of incapacity by two physicians or one physician and one licensed advanced practice clinician who examines the principal and signs a statement specifying incapacity. Now, I've done this for 40 years. I will tell you that in the vast, vast majority of situations, there is little doubt that a person has become incapacitated. But I have been in hospitals on a Friday afternoon, and the document the person has says we need to get two physicians, and that's not always easy to do. And so that person may be stuck in the hospital until the following week when we get set up. Most documents that I prepare, I reduce this requirement to one. My explanation to my clients are if you have doubts, you can always get a second opinion, but don't mandate it in every single set of circumstances. Another point that is often overlooked is that an individual can make a healthcare power of attorney effective immediately. So let's take an example of someone who has MS or another condition where maybe they get steroid treatments or other kinds of treatments where maybe there's periods, for lack of a better word, they're a little loopy, and maybe they're not really capable of making their own decision. That may be a circumstance where we make the healthcare power of attorney effective immediately. Now, if that person is of sound mind and they can make their own decisions, they always will supersede the healthcare agent. But if they're in a period where it's difficult, If you've made that effective immediately, the agent can step in and help make decisions and get care rendered as soon as you think care should be rendered. There's no delay. The execution, I almost deleted this slide, but we see too often where someone is calling and they're telling us that they did maybe the state form, and they're at a hospital and they're being told it's not valid. And often it's just because they didn't have the right witnesses. It wasn't signed properly. Physical inability does not prevent you from doing a healthcare power, because our statutes say that you can designate another person who is an adult to sign on your behalf. And there are ways to draft the documents to make that clear, that that is what you're doing. Then who can be a witness? We have people who say, can you mail it out to me? I can't come in, but I'll get it witnessed. And we try our best in the letter to say who cannot be a witness. Sometimes the document is returned and we see they've had a son-in-law or another family member witness it, or they've even had the healthcare agent witness it. You can't do that. You simply can't do that. Basically, nobody related by blood or marriage, nobody who's financially responsible for your healthcare, not the healthcare agent, and also can't be an individual who's a healthcare provider who's serving the principal at the time of execution. And sometimes it's amazing how we have family members who are nurses and other assistants, and they're in the process of providing care at the time. They can't be a witness. If there's a reason we try to get clients to execute those documents with us, is we know that's not going to happen. We know it's going to be executed appropriately. Now, I want to switch gears for a second. The declaration to healthcare professionals or the living will. I have on this slide only one of the questions that's on this form. And you can see it's basically saying that if I have a terminal condition that's been determined as we've indicated, I do not want my dying to be artificially prolonged, and I do not want life-sustaining procedures to be used. And in addition, the following are my directions. And I could check, no, I do not want feeding tubes used. And this is part of a personal preference, but it's not just shared by me. If there is somebody who can act as a healthcare agent, I rarely do this living will, because in my opinion, this living will is a mandate. And I've had this happen as a mandate before, and I'm going to give you an example. I had an 88-year-old person who was in the hospital, was not a client of mine, and they had done this living will, and they had checked no to this question. And in the hospital, the doctors had basically said, this person is terminal. So the son was being told, so your father can't be fed by tubes. He's not going to be fed, because this is the document we have, and he says, if he's deemed to be terminal, don't feed him by tubes. The son did not agree with the physicians. So the son is calling us saying, what do I do? Unfortunately, there wasn't a lot of answers, because this document supersedes any healthcare power, because you've done this living will document. And so we could try to go into court. Even an emergency guardianship wasn't going to happen right away. And so by the time we got any ruling, even if the ruling was in favor of the son, which I don't know if it would have been, it would have probably been too late. So when do I do a living will? I do a living will when someone basically has no family left, no family, no friends, nobody they can trust as a healthcare agent. Then I would do the living will. Or if we have family members that they don't trust to act in that capacity. And that happens sometimes as well. And under those circumstances, I would also do a living will. Now, we get caught up because we read these stories about all of these terrible life support decisions where somebody was kept on life support for years and the family is fighting in court. And those certainly happen. But I will tell you, for every life support situation, we probably have 100 situations where we're trying to use this document simply to admit somebody for care. And if you don't have this healthcare power of attorney where you've authorized the agent to admit you to a long-term care facility or to an assisted living facility, no one has that right. My wife does not have that right just because she's my wife. The spousal relationship does not confer that authority. Many times when people pick up these forms on their own, I know what they're thinking because I've had people tell me this in meetings. They read that question and they're thinking, nope, I don't want to go to a nursing home. So they check, no, my agent does not have that authority. Unfortunately, that's not what that means. What that means is if that person ever needs to be somewhere for care, since they have not given the agent the authority through a healthcare power of attorney, that agent is going to have to start a court guardianship process in order to admit that person for care. Wisconsin does not have a mental health care power of attorney. This is what is in our state statute that applies to a healthcare power. And you can see it specifically says may not admit or commit the principal on an inpatient basis to an institution for mental diseases, an intermediate care facility for the mentally retarded, a state treatment facility, and the healthcare agent may not consent to experimental mental health research, psychosurgery, electroconvulsive treatment, etc. Now, you can attempt to incorporate mental health treatment in your document, but there are severe limitations in Wisconsin. In a minute, I'm going to talk about what some other states allow to give you an idea what you may want to do, number one, if you happen to be in one of those states, but also so that you have a better understanding of the problems that you may have if you live in Wisconsin. Now, people don't like to talk about this, big surprise. The same reason why 75% of people don't have a will. It's an easy topic to avoid. There is a document out there that you can easily find by Googling, and I can also provide it to the foundation to add to this, 25 suggested topics to discuss with your healthcare agent. On the following slide, though, I've given you a number of other resources. This document is surprisingly taken lightly. I can't tell you how many times I've heard somebody say, oh, just prepare the document. I want her to be able to pull the plug. And that's all they want to think about. But unfortunately, it isn't scripted that way. These things can happen when you go in for routine surgery and something goes wrong. You could be a young person and suddenly have an accident. These topics need dialogue. They need dialogue with your healthcare agent. There's one site here I want to pick on for a second, and it's an ABA site that has a toolkit. And I want to give you just a flavor. Now, this toolkit does not create your advance directive. What it's intended to do is let you and your agent be thoroughly prepared to create that advance directive. There are 8 tools in this kit. I've only had a handful of my clients do this because, frankly, you really have to be prepared to spend some time. But I'm just going to read you briefly the 8 tools. One, how do you select your agent? What are your goals near the end of life? How do you weigh the odds of survival? What are your personal priorities or spiritual values? What are your after-death decisions you need to consider? There are scripts that you can have to help talk to your agent. There's a little quiz you can fill out that indicates how you feel, and then what do you do with the document after you sign? So I'm going to pick out this quiz, for example, and I'm not going to read much to you, but I'm going to read you a couple of questions. So it says, which of the following do you fear most near the end of life? Number 1, being in pain. Number 2, losing the ability to think. Or 3, being a financial burden on loved ones. And these questions give you different scenarios to imagine. Now, I'm going to divert, and I always pick on my wife, but I'm going to tell you, a few years ago when we decided it was time to talk to our son a little bit about this, because he was our alternate healthcare agent, we invited him over. And I told my wife, I said, well, Nancy, let's talk about some situations. So the first thing she says to our son is, well, okay, so if you walk in and I'm lying on the floor unconscious, don't do anything. And we both look at her. Well, what do you mean, don't do anything? We're just supposed to step over you? Now, I knew what she meant, because there had been these commercials on TV about somebody who had had a stroke, and it talked about their being trapped in their body. And she told me, I don't know how many times, she never wanted that. So I knew what she meant. But it took us a while to get some dialogue going before our son knew what she meant. Something else to consider, we do a lot of healthcare powers of attorney that are tailored to different faiths. There are different addendums that have been approved by the Catholic Church for addendums on life support language. For those of the Jewish faith, there are different considerations that we've drafted for Christian Scientists. This may not be at all important to you, but for many of our clients, it is. We've had clients talk to their priest, talk to their rabbi, and given us other suggestions for what to incorporate in their document. Now, I told you about the fact Wisconsin doesn't have this. I want to give you a flavor, though, of what we could have. And my personal feeling is I wish we would. In Arizona, one of the statements on their mental health care power of attorney says this mental health care power of attorney or any portion of it may not be revoked, and any designated agent may not be disqualified by me during times that I am found to be unable to give informed consent. Now you notice that last part, that's a lesser standard. We're not saying this person has to be adjudicated incompetent. We don't have to say they've been totally incapacitated. They have to be unable to give informed consent. So if somebody has temporarily gone off medications, and we've had this happen in Wisconsin where the mother or dad calls up and says, well, he sent me a letter and he's revoked my power of attorney. Well, yeah, he can. And we're back to square one. Another state or two has specific questions where you can answer to consent to the administration of some of that therapy that I showed you on our Wisconsin healthcare power of attorney. You cannot do by law. You can indicate the types of medication that you would approve. Now, again, this takes some real thought, but you have the ability to perhaps better deal with some of those mental health care situations. I like to end with this slide because not only do we not like to think about this, we don't like to talk to family. And sometimes when I have people that are, let's say, in their 50s or older, and they go and sit down to talk to their kids about it, the kids are the ones that say, I don't want to hear this. I don't want to think about this. You can't bury your head in the sand. And the sooner you talk about this, the better. We do a lot of hospital signings. We do a lot of signings in facilities, not so much with COVID, but before COVID. And it's good if we can get those signed because the person doesn't have the incapacity yet that would make it impossible for them to sign. But trust me, doing this around the hospital bed when someone's looking something really serious in the face, it's just not the best way to do it. And also, my other big surprise, maybe your family's different. Family members don't always get along. And it becomes a power struggle. I've had individuals call me and they say, well, my sister's my mom's healthcare agent. She won't tell me anything that's going on. And sometimes I'll say, well, let me call the sister, let me reach out to her. And sometimes what comes out of her mouth is, hey, I'm the healthcare agent. I don't need to tell them what I'm doing. That happens a lot with financial power of attorney as well. We've actually started building into some of our documents specifically, we want this person to provide information, to share information on the financial document, upon reasonable request to provide financial information. This should not be a secret. And unfortunately, the power struggle happens a lot more than what you would think it does. So again, if I can recap it all, do this sooner than later. Discuss it, talk about it, look at your options. A lot of those forms that are available on that slide I gave you that have 5 wishes or have honoring choices Wisconsin, I don't have anything against the forms. They're not bad forms. But almost all of those forms insist upon 2 physicians defining incapacity. And I find that some of the forms inadvertently, I think, limit the authority that you can give your healthcare agent. I think a drafted form tailored to your situation is going to better ensure that your wishes are carried out.
Thank you very much. Thank you, Terry. That was incredible. I had reviewed the slides before, but then hearing you discussing them really gave me a much better perspective as well. My question to you is that you said that 70% of people don't have a living will. The question is why?
I'll tell you my feeling. I think for married people, many couples have this false idea that just because you're married, you can do all those things. You know, the joke I always say when I speak to people is, you get this idea that just because you're married, you get all these rights. You should understand that when you get married, you give up all your rights, to bum bum. So you don't have those rights. I think you combine that with, it's not a subject people like to think about. And then you have a certain amount of people who have it's never going to happen to me. I don't know how else to describe it, Adel. These are comments we get. I think it's lack of education sometimes. Despite the fact that there's countless articles that appear in our newspapers and online and by presentations that try to bring this home, it creates a lot of problems because I'm telling you that if you've ever gone through a court guardianship, it's not a pleasant process. And a court guardianship, part of that process is that the person who is alleged to be incapacitated, because remember, it's an allegation. They are visited by an attorney who is appointed as a guardian ad litem, and that guardian ad litem will read them certain rights they have, and one of those rights is the right to be represented by an attorney. And I don't know if it's our upbringing, but you would be amazed at how many people, when they hear that, say, I want to be represented by an attorney. And now it is a potentially contested guardianship, which is even more unpleasant. Unless somebody has nobody to care for them that has to have a court-appointed person, or unless there's a dispute in the family that can't be resolved otherwise, you don't want to go through the guardianship process.
I completely agree. Having practiced medicine for a long time and seeing thousands of patients, those kind of situations were very, very challenging and very difficult. And I can't tell you how many times, we sat with a patient on the respirator on 5 pressors and still can't figure out where to go. Knowing what you know about how is living will in other countries, in Western countries, in Japan? Are they dealt differently, or are we the only people in the world that think that we're never going to die?
Let's go back to dementia and things like that. There are some states in this country that are more lenient on when certain things can be done that might hasten the moment of death. I think, as I recall, and maybe I'm wrong on this, so I'm not giving you a 100% guarantee, but it seems like Switzerland is the one country that, with the proper paperwork, if you want to end your life, that's one of the countries you can go to. So we have, I don't know, in a way, I think most other countries have a different attitude toward impending death. And it's not the prevent death at all costs. I think it's more of an acceptance. It's more of a discussion of quality of life versus continuation of life. We have incorporated that in some of our documents where people say, I do not want to continue my life under these circumstances. So we've expressly put in the document that they can travel to other states, they can use funds if necessary to get to sometimes people have referred to specific countries in order to carry out those wishes. So yeah, I think that if anything, in my opinion, we are, I don't know whether the right word is to say hung up, but we are more stringent on continuing life at all costs. And I'm not here to say that's right or wrong. It's just my opinion of how we approach this.
Yeah. Well, death is not an option. I think we've seen that many times over the years. I have a question here. Can guardianship be revoked?
If the guardian's not doing their duty, so if you think a guardian is abusing their authority, a good example is guardianship over the estate, where someone thinks the person who's the guardian is using the ward's funds for their own purposes. You can petition the court to have the guardian removed. You have to be able to demonstrate cause. But similar with powers of attorney, because of abuses, we have a state statute now that provides a procedure where you can bring a court action if you think the financial agent under a power of attorney is abusing their authority. What we struggle with is we get the call sometimes by a family member who really just thinks they should be the agent. And so they initially say, well, my brother, he's not doing what he's supposed to do. But when we start digging into it, we see the baggage of childhood and growing up, and we don't always get along with our siblings. And it's not a matter of the person not doing their job. It's a matter of sibling disagreements.
One question I have, with COVID being now in play, when you have in your living will that, when I'm in a position where I'm incapacitated and there's obviously nothing else to do for me, I don't want any of this done. But what happened in the situation where you have a disease that we don't know, if there's any treatment for it? We don't know. I mean, this is just out of the realm of everyday illness that we've had. I mean, how do you account for unusual circumstances or circumstances like COVID or other illnesses that might wrap up that might have a cure?
I don't think you do. I really don't. COVID, let's just stay with COVID for a minute. COVID has presented so many problems in our thought process. So a good example is, say you have a healthcare power and now you're taken to the hospital because you were diagnosed with COVID and you're having symptoms. Well, does that agent, does the doctor isn't saying that the person is yet incapacitated, or maybe they are. So then the question is, if they said no feeding tubes, how about breathing tubes? Is the document broad enough to say the agent can discontinue feeding tubes? And then it's a matter of the agent making that decision if all of those other factors are lined up. COVID has added so many issues. The other issue with COVID for us is trying to get documents signed. When the weather was nicer, some facilities would at least let the person come out to the lobby or just outside the lobby. We were passing documents through windows. Now it's pretty much a lockdown. And unless we can somehow get enough people that are there that qualify as witnesses, We can't get documents executed. So I wish I had an answer though on the COVID or the other. It's similar though, Adel, to somebody who says, no, I'm never going to say they can end my life. And I've had clients come in and pull out a newspaper story that they've kept from gosh knows when that talks about somebody who woke up from a coma after 10 years. Well, yeah, there are those stories. I don't think it's likely. I don't think it's prominent. But we've had people who've executed healthcare agents that have done the opposite, who says, I want you to keep me alive at all costs, using any kind of treatment, because they say what you just said. What if they come up with a cure?
Mm-hmm.
What if I come out of the coma?
Yeah. That came up, actually, a friend of mine whose father is demented. He's at a long-term care facility with the vaccine. Do we vaccine someone who's incapacitated, demented, and really have a very so is this mandate? I mean, do we want to provide across the board vaccine and giving to people who don't really have a decent life expectancy or decent quality of life?
Yeah, and that's a slippery slope because once you start drawing those exceptions, where do you draw the line? And I wish, anytime we're talking about this, Adel, when you're talking about life and death and illnesses and dementia, we're so often sliding into the gray rather than the black or white, and I think that's what makes this so hard. Right. The only final comment that I would make too on incapacity and why I encourage people to do these sooner is we are, as attorneys, put in the position sometimes where somebody comes into our office and we are the ones trying to be sure that this person has the capacity to sign the document, because they obviously maybe have early dementia or they have some other signs. So we have to go through some steps to try to be assured that they indeed understand what they're doing.
Right. Well, really make this create a change, that environment that we really have more than 75% of people not having will. What would you do? What would be the first step that you would really do? Would you try to bring the education to the high school level?
Yes, I was going to say that's the very first thing I would do. I would bring it to the high school level. I would probably try to include it at the college level. A lot of the high schools are already, when they have these adult enrichment programs for the community, often they will have attorneys make presentations. I would encourage that. Anything you can do at a younger level to make people aware. Now, the problem you're going to have, I mean, unless you run into different 18-year-olds than I do, you're pretty much still infallible at age 18. And it's still going to be hard to get people to recognize. But maybe if you plant the seed. I don't know if hospitals, I know they ask people when they come in if you have a healthcare power. I don't know if there's any education when people go home with their first baby or something to give a packet telling people about the healthcare powers and the importance. I don't think you could do enough. Do it at every level that you can.
It's the quickest, fastest way of really getting a living will done without having to go to an attorney and spending money.
Okay, go look at those sites, get the form, and complete it. And sometimes we get calls like that where people are very honest, and we have good communications with our clients, and they'll say, look, I know I want a new healthcare power. I just don't want to come in and have you guys do it. And we'll say right away, well, look, if it's between doing nothing, no, definitely go to one of those sites, get the form, get it done. And that's easy. I mean, I gave you even the state of Wisconsin site that you can print it off, and they've got really pretty good directions. Any of those other sites that have a form available, they comply with the laws of the state of Wisconsin. Do that, please, rather than having nothing.
What is the situation for people, adults who have development disabilities? who typically acts as their advocate if it can't be parents or family?
Okay, I'm not sure if the question is geared to the healthcare having a healthcare power. The first question would be, do they still understand enough? Are they capable of doing it? But we also have in Wisconsin, and I know I'm going to draw a blank now, we have another set of statutes where you can have, I'm embarrassed now, I can't think of it. It's been in the law about 3 years now, where you can have somebody help you make decisions. You don't have to have them as a power of attorney, but you can delineate the areas that they can help you with. And they have the authority to do so if you've executed such a document. If that doesn't answer the question, please ask it again, and I'll try to do a better job.
It looks like that was acceptable as the answer. Yeah. That is really a challenge, though. You're dealing with adults who have chromosomal deficiency or who have development issues and really can't make their own decisions. So having somebody along their side helping them in making that decision is you think is the way to go, or the way it is available.
Yeah, and obviously if they were very much incapacitated, to be honest, they probably have a guardian.
I already have a guardian. Yes, exactly. Yeah. Cool. Yeah, I think that we've got all of our questions, and then I know that we have plenty of time left, but I think we can wrap this up. And thank you so much, Terry, for really doing such a wonderful presentation, thorough, informative, with resources that can help us and help all of us who are listening to go ahead and get that living will done.
No, thanks for the opportunity, Al.
You bet. And for all of you watching or listening, I thank you so much for being part of our webinar today and podcast. If you're listening, I also want to remind you that the A.B. Korkor Foundation is here to help you and support you, but we also need your help and support. To support us, you can go to abkf.org and press on that donate button. It will make a difference for all of us. Many thanks for joining me today, and I look forward to seeing you in the future. Thank you again.